modern society, I'm sure every one of you will recall the first day we have discussed about whenever we utter a word like law, what does it mean? Whether the word law conveys anything. In a lay person understanding, law is nothing but a kind of rule or a regulation which aims at controlling or regulating human conduct. Why the conduct in a given situation requires to be controlled or regulated is always a matter of debate and deliberation. Depending upon the social needs, depending upon the nature of the incidents, depending upon how and to what extent the conduct in courts reflects upon other person's rights and duties. For instance, nowadays we talk so much about ragging in the educational campuses. 10 years ago we never even felt the need for any law controlling such kind of conduct. But now we felt, no, it is going beyond the kind of realm and proposition. Therefore, there is a need for controlling and regulating the conduct. Similarly, sexual harassment. Sexual harassment is something, no doubt, internationally, globally, many people felt there is a need for protecting the gender interest. But in our own cultural context, it was never thought in that way. But of late, people started realizing it is not just an isolated incident or something. In many circumstances, many contexts, such a kind of behavior is on the rise. Therefore, with a view to protect the gender interest, there is a need for a legal control. That's how the law came into being. In that way, there are certain things which are universal in nature, which means, for example, killing. Killing is universal. Wherever, whichever country, whichever geographical territory, it is an offense. But there are certain things which may be offenses in this country, may not be offenses in that country. That is the reason why whether there is a need for regulation or not is a societal specific inquiry. I hope I am communicating. In the society, depending upon the situation, etc., then the people will decide whether there is a need. For instance, sati or dowry. I don't think you will find these problems in other parts of the world, because culturally they were absolutely non-existent in nature. But speaking for our own context, or in Asian continent maybe, because dowry problem, I am told, it is not only in India, in a couple of other countries are also there. Therefore, culturally some kind of a spin-off problem where the parliamentarians and legislators felt there is a need for law. Therefore, law requires to be understood and appreciated in the cultural backdrop of a given territorial jurisdiction. Then you are in a better position to understand. If this is the premise, there are certain technical categorization about law. I think particularly when we talk about bioethics, a training program, I think these technical information also you need to be aware. So that whenever, for instance, you are given a particular statute pertaining to biomedical waste disposal, when you read that, you need to understand why such a word is used, what is this law, and what are the categorizations, what are the various branches of law. Suppose if the person doesn't comply with the law, what happens? Where do you go to the, where do you obtain the relief? Suppose your individual right is violated. Where would you want to go to get the relief? How do you redress your grievance? Which is the organization responsible for? All this information I will put it in a nutshell for about 30 minutes. Now, to begin with, this is one phrase which I think of late assumed a lot of significance. That is, whenever we talk about law, it connotes two important aspects. Number one, substantive law and procedural law. Substantive law means the law which deals with rights, duties on one hand, or offenses and punishments. Again, the branch which deals with offences and punishments is called criminal law. The branch which deals with rights and duties is called civil law. I think this categorization at the outset you need to understand. I'll give a contemporary example. Of late, many people started talking about filing criminal cases against doctors under criminal law. I'm sure you must have heard about it. That is invoking section 304A of Indian Penal Code, which deals with rash or negligent conduct resulting in death of a human being. For example, medical negligence resulting in death. There are certain circumstances where the criminal prosecution is launched against the doctor. That is the criminal. Okay? There are cases where the patient prefers to file a case against the doctor in a consumer forum or in a regular civil court. I will tell you the difference bit later. But this branch is called civil law. In other words, any law which deals with rights and duties, it is called substantive law. Any law which in a different, the context where it deals with the procedure to be followed. For instance, you want to file a case against a doctor on the ground that there was a medical negligence. Which court you will prefer? Okay. You may prefer even civil also. Within civil, you may prefer consumer court. Consumer court, which court? How do you invoke the jurisdiction? What is the document you have to file? After the document you file, that is called a procedure. Substantive means in law, in prescription, it says, suppose there is a negligence or deficiency of service on the part of a service provider. As a consumer, you are entitled to seek redressal. You are entitled to remedy. That is called substantive law. Okay? The law which deals with the procedure, which court you will go, what kind of document you will file, what is that is required in order to file a case against an individual. Whenever you want to file a case, the procedure what you have to follow, there is a law. If you do not comply with that law, you are not entitled to seek legal remedy. Okay? Substantive law which deals with in civil rights and duties, in criminal which talks about offences and punishments. For instance, Indian Penal Code, the substantive penal code of the country. What is the major purpose of this code? To define offences and prescribe punishments. That's all, nothing more than that. That is the reason why Indian Penal Code is called substantive criminal law. Similarly, X wants to marry Y, belonging to a particular religion. Could be Hindu or Muslim or Christian or Parsi or intercommunal or interreligious or intercaste, you name it. There are certain laws. Hindu Marriage Act 1955, which deals with the rights and duties of the people who would want to marry. What is the procedure, etc. Suppose after 1 year, they want to seek divorce. Okay? In such a case, which court you have to file? Is it before a family court or is it before some other court? If so, what is the document you have to file? What is the content you have to mention? What is that you need to prove to get a divorce? That is a matter of procedure. Okay? Similarly, in criminal law, whenever a particular offense, I am sure you agree with me, if the law says that this is the conduct which is an offense, the definition must be very precise and very, very focused in nature. And accordingly, the person is said to have or alleged to have committed the offense. For instance, a small and a very lay person offense, let us take. I know that you are not law students, but as a matter of popular understanding, I would want to know. Can anybody tell me what is theft? Stealing. What is that? When you can say that a person has stolen, what is that is required in order to say that he has committed stealing? Okay, others' property. I cannot steal my own property. Fundamental. Correct? You are right. Others' property. Next, move on. Consent, which means I am not stealing, I am taking. Simple. Lay person. If you, suppose I snatch your wallet or purse. Snatch means what? Without your consent. Suppose I am trying, she says, Professor Jogaru, take it. Why you want to do all that? She gives it to me. I will take it. I did not commit an offense of theft. I took it. There may be a circumstance where that giving may not be voluntarily, with free will. There may be some kind of, I must have shown some knife or some pistol or something like that. Or verbally, I might have assaulted, saying that I am going to kill you, I am going to do this, or I am going to kidnap your child, or this. All these things. In such a case, it is not theft, but it is something else. Because whenever we say theft popularly, that you do not know, please understand, you do not know, which means you have not consented for taking the property. You agree? In other words, if this definition is there, please remember, if Jogara or X or YZ commits that, law should specify, okay, this is an offense of theft. Okay, for which what is the punishment? 3 years, 6 months, 2 years, 7 years, etc., etc. Suppose as our friend said, no, he has not only come to, taken away my property, but he threatened. Please remember, section 391, 390, it amounts to robbery. If you threat, there is a kind of attempt to assault or to take away the property, in such circumstances, it amounts to robbery. And if the same offense is committed by 5 people, it amounts to dacoity. That is how the definitions are made out. All this you will find in Indian Penal Code. That is why it is called criminal law, which is substantive law. Okay? Now come to the procedure. Now doctor came to know that Jogara has stolen. What do we do? She has to inform police. What do you file before police? FIR. What is FIR? First information report. What do you mean by first information report? It is the report made to the competent police officer so that upon conducting inquiry, he or she would decide whether there is an allegation against Jogara or X or Y or Z. Accordingly, the procedure is to be followed. What is the procedure? What is the first step in the procedure? Investigation ayathu. Next. First thing is arrest. Arrest. The person must be fetched. You need to fetch the presence of the accused. It could be bailable offense, it could be a non-bailable offense. Depending upon that, the person will get the bail. But the person will be produced before the competent court. Then the court may say, produce him after 14 days remand. Remand means he will be in the custody. Or he may be released on bail. Then he will give a surety. Then the procedure starts. After evidence, charge sheet, everything. Then the court may come to a conclusion. No, there is no offense because prosecution has not proved the evidence. Or prosecution has succeeded in proving, accordingly, X is convicted for 6 months rigorous imprisonment. That is called a person whose guilt is recorded is called convict. Okay? Whoever is the convict, the punishment must be pronounced. Okay? If the person who is facing the proceeding, the judgment is not delivered or the case is not complete, he is called under trial. Okay? If the person against whom the evidence is not there, then the person is called acquitted. These are all technical jargon to indicate the various procedures. In India, we have procedural laws which deals with civil law and which deals with criminal law. For instance, Civil Procedure Code, Code of Criminal Procedure. For instance, the person is to be arrested. Simple question I am asking you. Please tell me. Whether a police officer can arrest a person without a warrant? First thing. What do you mean by warrant? A written authorization empowering the police officer. In quotes, police officer means, station house officer above. It could be head constable above. In such circumstances, the person can show the warrant to the person concerned and accordingly declare, you are under arrest. Now the issue is whether a police officer can arrest without a warrant. under certain circumstances, a police officer is competent. Yeah, popularly we call that, but the law makes a distinction called cognizable offense and non-cognizable offense. Cognizable offense means, put it lay, serious offenses. Murder, kidnapping, robbery, dacoity. These are all serious offenses, where the person, if there is a credible information or reasonable complaint or reasonable suspicion, please remember, if either of these three are there, the person can be arrested even though the person is not, there is no warrant. I'll give a simple example for where the police officer must have a warrant to arrest. You know check bouncing? Do you know that it is an offense? You heard about it? Under section 138 of Negotiable Instruments Act 1882, if I draw a check in favor of my friend and she collects the check and deposits in her account, and the check is returned saying that insufficient funds, on that ground she can file a complaint against me that Jogaro gave such kind of check, etc., etc. On the ground of insufficient funds, it got bounced. It is an offense. But it is a non-cognizable offense. What do you mean by non-cognizable offense? She cannot go to the police and ask him to arrest me directly. No, that is not possible. She can only file a complaint before the magistrate, and magistrate looks into all the facts, etc. Okay, now I am convinced that Jogaro has committed this offense. Then the concerned police jurisdiction, okay, that particular area, he gives an instruction, go and bring Jogaro here. That is called arrest with warrant. A non-cognizable offense means without warrant the police officer cannot arrest. Okay, all these details including sentence, life imprisonment, death sentence, appeal, so many facets are covered under Code of Criminal Procedure. That is the reason why if anybody says that he or she is a lawyer, not only he or she should be knowledgeable in substantive law, you should be more knowledgeable in procedural law. Procedural law is a matter of practical enforcement, practical application. You need to know which document when to file, how to file, what is to be written, which court is to be filed, what kind of bond, what kind of surety. Everything you should have on your fingertips. Particularly criminal trial, time is very, very significant. For instance, a person like Sanjay Dutt, when I say Sanjay Dutt, because he is a celebrity. He is not like Jogaro or XYZ. He is a different world. Not only by virtue that he committed an offense, that is not the issue, even otherwise. When the Supreme Court passed an order releasing him on bail, how many days it took for the Eravada prison to receive the official copy? Unless the document is received by the prison authority, the person cannot be released on bail. It could happen only yesterday. It took 3 days. Because there are several procedures, so many things are there. You can't just say that Supreme Court announced, I have seen CNN and IBN, he will be released here. No, that is not possible. Because the procedure is that authentic document from the concerned registry must be communicated to the prison authority. Then accordingly, the DGP of prisons, it comes down and the concerned inspector, accordingly, all the examination, everything. Then why I am saying is all these procedures, please remember, must be complied with whatever that has been written in the same thing in the, same thing in the case of civil procedure code. Whenever you want to file a case, please remember the document, whether you should have a case. For instance, I will ask a simple question, a lay person, common sense. You want to file a case against me, okay? As a doctor, I did some wrong, that's what you think. What is that you need to show to file a case? What is that? That is what we call, very important, cause of action. In civil matters, if at all you want to file a case, you need to have cause of action. Why do you want to file case against doctor? That you need to mention. I hope I am communicating. The cause of action not only in medical negligence case, in any civil case. For instance, I and you enter into a contract. As usual, you perform all your obligations, I don't perform. That is called breach of contract. Breach means failure to perform. She is entitled to file a case against Jogaro. But in the document which you file before the court, you must mention such and such date we entered into a contract. The contract has envisaged these obligations. I have performed these obligations 1, 2, 3, 4. But Jogaro never turned up, etc., etc. Therefore, he committed a breach of contract. All that you have to make out a case. That is called cause of action. If you do not specifically bring the court's attention to this aspect, the case you cannot file. Therefore, in every civil matter, please remember, cause of action is something fundamental. Even in medical negligence cases also, normally. But in medical negligence cases, what happens is, it is a bit scientific and complex matter. Therefore, whether injury on the face of it should be taken into consideration, is it adequate, is it enough, generally lay judges may not be able to appreciate. I mean, as a doctor, you may say, for instance, tubectomy you have conducted, she conceives after 3 years. You may say, no, natural recanalization. But for a lay judge, no, the very fact that she conceived after 3 years indicates some problem. That's what he or she thinks. Therefore, generally, popularly, medical negligence cases, whenever you show an adverse consequence, that is constituted to be cause of action. For instance, ketamine you have administered. Within 3 minutes, the person dies. You may say that this is the thing, that is the thing, in my 18 years of experience, the first case, so many things you may say. But the judge definitely will consider it as a cause of action, saying that he wants to know, tell me in this case, how come the patient is no more? Why? What is the reason? So many issues will come, etc. Same thing, in that way, there are certain very simple interventions, but still the kind of situation may be out of hand. An adverse consequence may happen. In that way, please remember, in civil cases, cause of action is something very, very significant. Substantive law, procedural law, civil law, criminal law. Civil law, there are so much, branches are there. For instance, labor, it is brought under civil. Marriage related, civil. Property related, hereditary. Contract related, or your rash driving negligence. That almost various facets are. Criminal also, there are various statutes, etc. That's where I want to tell you, even in healthcare context, criminal laws also are relevant for you. For example, Transplantation of Human Organs Act 1994, there are certain offences. Mental Health Act 1987, there are certain offences. MTP, there are certain offences. And more importantly, biomedical waste rules and regulations, there are certain offences. Therefore, you need to know, whenever we talk about criminal prosecution, these are the things that could happen. Okay? Final word about the particular law in the society theme. Whenever we say law, there is another categorization which I think you need to know, that is called statutory law or statute or act or code, which means the law explicitly written down, specifically, explicitly written down. That is called statute. Medical Termination of Pregnancy Act 2003 is a statute, is a code, is an act. Act, code, they convey more or less the same thing. In good olden days, there was a difference, but now there is, doesn't. Okay? There is another branch which I think is very significant for all of us to know. Common law. Common law means where the law is not written. The law is not written. You remember the first day I said constitution can be a written constitution, unwritten constitution. Same thing, law can be statute, which means written. Common law means unwritten. For your information, the most significant area of medical litigation in this country is medical negligence. Medical negligence in civil matter is common law. What constitutes negligence? When can you say that a doctor is negligent? He is a matter of common law. That is the reason why in civil law, as I told you, there are so many branches. One technical branch is there. It is called tort law, which means law of civil wrongs. tort, T-O-R-T, means civil law. For example, rash driving resulting in the person can file a case, etc. It's a matter of tort, where the law is not statutory, law is common law. Therefore, what is negligence? What is that you need to show that there is negligence is a matter of common law, tort law. Like that, there are several civil wrong. Negligence, nuisance, trespass. Suppose somebody enters into your house without authorized, without proper invitation or license. That's called trespass. Trespass could be with regard to the premises. It could even be with regard to the body. Trespass against body also it is there. Like that, there are several civil wrongs are there. I think you just need to know to understand, whenever we talk about medical negligence in civil law is a matter of common law. But medical negligence in criminal law is a statute law, because it covered under section 304A. Yes, doctor. Now, in Indian context, criminal law can only be a matter of statutory law. If there is no statute, the person cannot be prosecuted. There doesn't matter, any branch, any area, criminal law, for example, X is prosecuted. Okay? The judge will ask, which offense? No, sir, there is a convention, that is the convention which is not written, that is the offense he has committed. Judge will not accept. For criminal law, you require a statutory prescription. Offense must have been defined. Punishment should have been prescribed. It ought to have been covered under Code of Criminal Procedure. Only when there is such, the person can be prosecuted, without which, no. Not only that, there is another thing. Suppose the law has come into force 1st July 2007. A person cannot be convicted for an act which he committed in the May. It's called ex post facto law. No question of retrospective operations, criminal law. It is violative of Article 21. A civil law could be retrospective, no problem. But criminal law cannot be. Yeah.
I was reading a paper today. That patient came from a village to Bangalore.
Correct.
He was complaining about stomachache.
Correct.
Then they refer him to another hospital.
Correct.
In that hospital, they refer him to another hospital again.
Correct.
In that hospital, they send him to the theater. Remove the kidney, gave it to somebody. Later, he cannot walk. His brother came. He found out that they have removed his kidney, and the doctor gave that patient 20,000 rupees.
Okay.
And he said, what is this for? He said, it is for the medical expenses. Now, the brother took this case to the court.
Okay.
That to the police, that they have removed his brother's kidney. Now, what he's complaining is that he didn't even know where the court is and which court he's going. That is the patient. Now, he's desperately here in Bangalore at the moment, in one bedroom or one room flat, sitting down, doesn't know what to do.
Correct.
So what is he going to do now?
Yeah. Yeah. Now, see, in terms of the jurisdiction aspect, I don't think there is any technical problem, because the alleged treatment or intervention, whatever, whether it is for stomachache or kidney stealing, etc., it has taken place in Bangalore. Therefore, Bangalore court has the jurisdiction, number one. And because he is filing FIR, he doesn't require any kind of legal service. The prosecution is borne by the state, and accordingly the police investigation will be conducted, etc., etc. The dilemma here is not initiating the proceeding. But when it comes to kidney, even now we are not clear. Under which legislation we have to do? Should we invoke it as an offense of theft or something else? That is the dilemma here. I know one prosecutor said an offense of cheating can be fastened under section 420, 416, etc., etc. Yeah, popularly speaking, cheating may be a track, that's what people consider. But my observation is, ultimately you come down to the issue whether organ of a living human being can be construed as a property. for Indian Penal Code or not. That is the issue. When I say this argument, please don't think that I am holding brief for the doctors who have snatched the kidney. Don't think that. I am not saying that. Here, if a person is there, we have to find out. When the earlier scandal has broken, I am sure some adequate steps must have been taken in order to see what is the appropriate law for this purpose. But that has not been done. That is the reason why some loophole here and there people will identify and occur. Or even innocent doctors also, those who did not involve, they may be facing the wrath of the people. I think that's the entire system of how the clearances take place, in what way the documentary evidence, everywhere there is a problem. Therefore, it is impossible as of now unless there is a statutory clarity. Okay? Transplantation of Human Organs Act only prohibits commercial dealing, but not theft, robbery, dacoity. Please remember. That is the reason why 1994 legislation is not applicable in this context. I am giving these examples only to drive home the point. Please understand, scientific, complex, or technical aspects are there. You need statutory clarity, particularly when there is an offence. If there is no definition of an offence, a person cannot be prosecuted under no circumstances. But in the case of civil law, there is a possibility because you may create that common law. You go to the judicial president, this judicial president, and try to borrow, try to adapt to the situation. But in criminal law, it is not. I conclude by saying, when we talk in terms of law, particularly as we make it applicable to the healthcare scenario, I think the basic foundational information of this nature is very, very essential for you. Okay?